scale of this source is amazing. And because over 240 years, there were over 200,000 trials which were reported in over 127 million words of text. We call the proceedings the largest body of text detailing the lives of non-elite people ever published. The extraordinary consistency and level of detailed reporting made the proceedings ideal for digitization. And in 1999, Tim Hitchcock at Sussex and I set out to create a digital edition of all surviving copies. The text was typed in, not OCR'd like most digital sources, resulting in a very accurate text, and then marked up in XML to enable structured searching. That is, XML tags were inserted around all the key pieces of information in the text: the offense, the names of defendants, victims, and witnesses, the plea, verdict, and punishment, and so on. This web-based resource was completed in 2008 and has been updated several times, most recently just last year. The first, most obvious approach to using the proceedings is to conduct keyword and various other types of structured searching. And you can see here that you can search by multiple categories of information. You can see that from our menu of search options. You can also compile statistics on topics of interest to legal historians: the nature of the criminal charges, defendant pleas, verdicts, and punishments. This allows you to count the 200,000 trials, or a subset thereof, according to a variety of criteria, and present the results in tables and charts. For example, here is a stacked bar chart showing the changing distribution of defendants' pleas over time. By far the most common plea at the Old Bailey was the straightforward guilty plea, shown here in blue. But from the early 19th century, an increasing number of defendants pleaded guilty. These are the pink parts of the bars. Why did these pleas become so common? It seems clearly to be a case of plea bargaining, but we don't exactly know how this worked. So statistics are a way of contextualizing individual search results. Another way of demonstrating context is through the macro graph, which we recently introduced. Like statistics, this methodology allows you to see the forest as well as the trees, or in the lingo of digital humanities, to carry out distant viewing as well as close reading of the text. The macroscope charts the word length of all the trials on the x-axis on a logarithmic scale, against on the that was on the y-axis, against on the x-axis the years in which the trials occurred. The gray dots represent all 200,000 trials in the proceedings. The red dots reflect the results of your search. In this example, murders in which the defendant was female are plotted in red. Unsurprisingly, these murders generated some of the longest trial reports in the proceedings, though with a group of much shorter trials in the late 19th century, owing to cases where the defendant pleaded guilty. Interestingly, the number of trials became more frequent towards the end of the period, suggesting that, although the overall number of female defendants declined over time, the number of murders women were accused of increased and were reported in detail. Here's another example of the macroscope generated with downloaded data, which shows the distribution of offenses by color over the period. We can see quite clearly here how property offenses in red gave way in the 19th century to cases involving violence in blue. Now, all this is fairly basic and works with the texts as presented in a single web resource. But we can do much more if we download the data to conduct further analysis and combine it with information from other digitized sources. As I said, one virtue of the Old Bailey Online is that the text was accurately rekeyed, facilitating detailed analysis of the language used and allowing it to be used in conjunction with other digital resources. This has led to the creation of several further digital resources, which include the text of the proceedings. For example, there's the Old Bailey Corpus, a database of spoken language reported in the proceedings, which was created by Magnus Huber at the University of Gießen, in which the spoken language is annotated with information about the socioeconomic status and courtroom role of the participants. We downloaded this annotated data and used it to analyze patterns of speech in Old Bailey trials, focusing on who did the speaking in court and when. And this led us to some surprising conclusions. Scholars using the Old Bailey proceedings before it was digitized charted the rise of the adversarial criminal trial, as lawyers came to be accepted in criminal trials in the 18th century. They hadn't before. And to argue that, in the case of defense lawyers, this silenced defendants who tended to simply leave their defense to their counsel. But our analysis of the corpus data has allowed us to put these developments into a much wider context and to discover other changes which allowed the modern criminal trial to develop. One of the things the proceedings was particularly bad at was recording the activities of lawyers. But nonetheless, careful reading of a sample of trials over the 18th and 19th centuries revealed a hitherto unknown pattern, in which for the first 130 years in which lawyers were present, lawyers for the defense, that is the orange bars in these charts, outnumbered those for the prosecution in blue, before suddenly, in the 1850s, prosecution counsel became almost ubiquitous in Old Bailey trials, outnumbering counsel for the defense. We're still trying to work out precisely why this change occurred. Now, although this data on the chart you see here was collected by old-fashioned manual reading of the reports, which is why it was only possible to sample the data, in principle, it should be possible to derive such information using natural language processing or artificial intelligence. Then, analyzing data from the Old Bailey corpus and conducting quite a bit of sorting, coding, and contextual reading, again, something that might well be performed by AI, we were able to identify most speakers by their role in the courtroom: defendant, victim, counsel, witness, judge, and jury. When analyzed over time, the results are significant. Victims and defendants and judges and jurors spoke less, while witnesses came to dominate the criminal trial, and they're blue in these bar charts. The emerging role of counsel is obscured in this data because the proceedings failed to report their interventions in any detail. Further research shows that these witnesses increasingly came to involve both police and medical experts. And all in all, this shows how the criminal trial evolved from a confrontation between victims and the accused to one dominated by professionals, lawyers, police, and medical experts. We can also perform semantic analysis of the entire text of the proceedings using techniques of linguistic analysis. In this example, 3 computational linguists identified contrasting synonym sets for trials involving violent and nonviolent acts. They identified a growing divergence after 1780 in the language used to describe these 2 categories of offenses, with violent acts discussed in terms increasingly which reflect an increasing intolerance of violence in the 19th century. Now, all this still is largely working with a single original source, the proceedings. But one of the great affordances of digitized sources is that they can be combined with different types of sources and content to allow wider conclusions to be drawn. And the Old Bailey Online has been reused and incorporated in this way in at least a dozen other digital resources, of which I will briefly mention a few. London Lives is a web resource which allows you to perform a combined search of a wide variety of primary sources in London's social history in the 18th century, including records of criminal justice, not only the Old Bailey, but also those from the lower courts and summary justice, poor relief, coroners, and tax collection. This allows you to trace the individual lives of defendants, victims, and other courtroom participants and obtained a more rounded picture of them. Similarly, the Digital Panopticon combines a wide variety of criminal justice and genealogical records from England and Australia in the 19th century to trace the judicial and wider lives of defendants who were convicted at the Old Bailey in the long 19th century. The website allows you to construct life archives containing all the records we have for specific individuals. So we can then see whether they were hanged or transported to Australia or imprisoned in England and assess the impact of their punishment. Did they reoffend? How was their family life affected? And so on. Here's a summary of the life archive of Mary Sherman, a shoplifter who was transported in 1833. In Australia, she was assigned to work as a domestic servant, but as you can see from her repeated absconding, service did not suit her. This was not necessarily a punishment which reformed her. Now, space is an increasingly important dimension of historical analysis. And we can map the crime locations in Old Bailey trials onto a fully GIS-compliant edition of John Roke's 1746 map of London, and overlay other data sets, such as those from London Lives, which reveal the geographical distribution of wealth. Here, we analyze the impact of a new type of policing agent, the Bow Street Runners, whose activities here are mapped in red, on prosecutions across London, so all prosecutions in London, which are here shown in blue, showing the runners' impact during their heyday. We see a concentration of efforts around Bow Street in the West End, unsurprisingly, but also a spread across the metropolis, emphasizing just how important they were to the development of policing in London. Another important kind of space is the courtroom itself. Here, we use a 3D reconstruction of George Dance's 1774 courtroom based on the original plans to identify the locations of the participants who spoke at trials. This allows us to see how the judges had a commanding presence in the courtroom, facing the defendant who was on the other side of the room at the back, with the witness stand closer to the judges and the jury. Sitting below everyone, but in the center of the courtroom, were the lawyers, encouraging them to speak loudly and use theatrical speech and gestures to command the attention of the room. This model allows us to assess relationships of power in the courtroom and to understand the way in which the internal courtroom architecture reinforced the specific roles and expectations of each of the courtroom participants. So, in sum, once a text is digitized, there are numerous ways you can analyze it beyond merely keyword searching, taking advantage of the affordances which digitized sources provide. But before I close, I'd like to mention a few caveats. First, and this may seem obvious, but people often forget it, once you rip words and details from their contexts, there's a danger of misinterpreting their significance. Whether you are doing simple keyword searching, or the most sophisticated linguistic analysis, or combining different types of sources to assemble life archives, you run the risk of misinterpreting your findings unless you have a full understanding of each of the sources you are using, their context, and their limitations. Now, in the case of the Old Bailey, I've written an entire article about this. It's important to know that these trial reports were not, as I said earlier, they're not transcripts of what was said in the courtroom. Although they often contain verbatim testimony, they left out or summarized well over half of what was said. This includes, as already mentioned, the speech of lawyers, but also, to some extent, that of defendants and judges. Also, cases which resulted in acquittals were reported more briefly. Essentially, the trial reports were edited by the publishers to present a particular image of justice to their audience, one which assured readers that criminals were duly convicted and punished. Needless to say, one can read the proceedings against the grain of the publisher's intentions, but this needs to be done in a careful and informed manner. Second, I'm aware that many of the digital sources that legal historians use, such as collections of statutes and precedents, are provided by commercial providers such as Westlaw, LexisNexis, and Hein Online, in contrast to the resources that I've discussed today, which have been published by universities. In addition to their inordinate expense, commercial resources suffer from two limitations. First, their search engines can often be opaque, which means it's not entirely clear which text you are actually searching, their limitations, and the limitations of how the search is being conducted, because the mechanisms behind the search are kept in an inaccessible black box. Second, owing to copyright and access restrictions, the full bodies of these texts cannot often readily be combined with other sources and analyzed using tools other than those provided on the website. This limits your ability to do the sorts of research enabled by the Old Bailey corpus or the digital panopticon. But one should bear in mind that under their contracts with UK university libraries, you sometimes have a right to download the datasets which underlie these commercial websites and independently analyze them offline. If you want to perform that kind of research, you should talk to your local librarian. These caveats notwithstanding, I hope I've made it clear this afternoon that there are many valuable opportunities available to those who wish to use digital history for legal historical research, and I'm happy to take any questions. Thank you.